I would like to inform you about uh, about assistance measures to the economy from private law perspective. An important operational role in the implementation of direct assistance measures to the economy has been assigned by Croatian Employment Service Bureau. Within the program of active employment policy from March 2020 until the beginning of this year, has implemented two measures to help the economy. First, support for job preservation in the crisis activities affected by coronavirus, and second, reduction of working hours. These measures were designed and implemented based on regular active employment policy measures regulated by a separate legislative instrument, the Civil Obligations Act, and in accordance with the strategic plans and programs of the government of Republic of Croatia. It was strategically decided to pay support to employers who were required to pass it on to workers, whether it was the first or the second measure. An employer who meets the prescribed publicly announced condition would enter into special private contract with the Bureau or Employment Service, based on which the aid was paid, either for the preservation of job or for the reduction of working hours. The balance sheet assets of such employers increased by the amount of paid aid, and they were obliged to prove to the office, that means to the bureau, based on individually concluded contracts, that the aid was redirected to the salaries of the specific number of employees for a specific period. As the received aid increases, the scope of the employer's balance sheet assets, and the employer is not obliged to return them to the office, that means to the bureau, the peculiarity and asymmetry of mutual obligation is noticeable. The measures should be viewed in the light of the public law restriction on free enterprise, and the aid paid can be said to be a kind of compensation for the imposed entrepreneurial prohibitions. Certain economic activities such as catering, tourism, transport, etc. were nearly paralyzed, which inevitably affected labor relations and increased the number of employed, while in some sectors such as informatics, communication, construction, etc., employment increased due to pandemics. The measures have mitigated the increase in the number of unemployed and vulnerable sectors. Unlike some European countries such as Federal Republic of Germany or Austria, the Republic of Croatia did not decide to pay a certain percentage of the difference in companies' income for the same amounts in the business year before the pandemic. But in Croatia, the support was directed exclusively through active employment policy measures. Both measures concerns only employees of employers whose businesses has deteriorated or been prevented by public law measures. The first measure is support for the preservation of job in activities affected by the pandemic. Every employer, regardless of the legal form in which it is established, is obliged to keep business books in accordance with the regulation governing accounting. The extent of the disruption of the economic activities of individual employer can be seen from those business books. However, the aid measure does not authorize the beneficiary to request the payment of the difference or part of the difference, which is shown in the company's books as a reduction in economic activity within the certain period. On the contrary, it is exclusively depend on the number of workers and employer whose business scope has been reduced because of public law measures can only claim support for each individual employee or worker. Based on active employment policy measure program, the Employment Service or Bureau is authorized to grant subsidies for the preservation of jobs. They are based on provision on Special Labor Market Act, are awarded to those employers who enter into special private law contract with the Employment Service. That public entity, that Employment Service, fully decides on the form and content of that contract for the award of support for the preservation of the job, determining the condition and ways of using the funds for the implementation active employment policy measures. Employment Service drafted a list of contractual clauses. The content of that contract thus formed is unchangeable, and co-contractors, that means that employer, do not have the possibility of individual negotiation on the particular contractual provision, nor can they point out their proposal in terms of narrowing or expanding the proposed content of that contract. The contract is concluded for the purpose of preserving jobs and to achieve the public interest. Its conclusion is regulated by compulsory public law provision from Labor Market Act, prima facie, that one should ask whether it is a legal private business or legal business by public law or an administrative contract. It is not administrative contract, it is private law contract between employer and bureau which grant that subsidies. The contract form was designed by Employment Service, so it is a standard or standardized contract. Given the urgency of measures to support entrepreneurs who have been prevented or hindered from the working and the number of the contracts that Employment Service had to conclude with employers, it was necessary to prepare the standard contract from that will be used to conclude numerous contracts. The number of employees and the time period for which the benefit is paid are adjusted to the individual employer, who is obliged to provide accurate data on employees. It is clear from the content of that contract that the contractors are mutually committed to specific action. The primary contractual obligation of Employment Service are to payment of support to the employee business account in a certain amount, that means about 530 euros for each employee in monthly installments for the recognized period of the supervision of whether the employer used the funds earmarked or pays salaries in accordance with the attached employment contracts. The primary obligation of employers are first, to pay the salary to employee, second, to submit to the Employment Service evidence, third, to submit to Employment Service and necessary documentation for the purpose period, and to retain the number of workers for whom the support has been paid, unless there is the reduction of the number of workers due to justified reasons. The worker is protected from the receiving a business-related termination of the employment contract, and at the same time the employment service is financially relieved because the worker will not become the addressee of receiving unemployment benefits precisely for the purpose of paying the support. The Employment Service has published on its own website the public call for the use of the active employment policy measure in the form of aid for the preservation of job in activities affected by COVID crisis. The invitation is offered to all employers who can be organized as companies, artisans, family farmers, even sports club, and so on. But also natural persons who are self-employed and who are insured on the basis and are liable for income taxes. Therefore, a natural person or a legal person is an employer, should perform an economic activity and be liable to pay income tax. The public call for the use of active employment policy measure, published electronically on the website of Employment Service, is not an offer or a general offer in terms of the provision of Croatia's Civil Obligation Act. It does not contain the essential components of the contract, nor can it be read from the sender's will to enter into the contract on the basis of which an unspecified addressee, that is employer, as a bidder, could accept the published condition by mere statement. The public invitation announced the assumption and condition under which the offer, that means bureau, of those employers to submit a bid for concluding a contract and who submit a request for supporter under the published condition will accept it. Without acceptance of the offer, the contract on granting support for job preservation cannot be created. The sender of the invitation to submit the bid may reject the bid for concluding a contract for justified reasons, and he may also do so because of unjustified reason or without a valid reason. Due to little time, I will just mention a few words about second measures of shortening working hours. That second measure also has been enforced in June 2020, and almost the whole year was in Croatia on force. The condition and methods of using the funds for the implementation of that measure, in comparison, the first measure was the 530 euro per each employee. This shortening working hours is about 300 euros per month per each employee who are under this condition. The aim of the second measure is to preserve jobs among employers whose work has been temporarily reduced due to special circumstances caused by coronavirus. The addressee or target group of the measures are employers who perform economic activity and employ 10 or more workers. Micro entrepreneurs employing less than 10 workers did not address those measures. The measure applied to all workers, regardless of whether they are employed for a definitive or indefinite period of time, who are employed by employers from the target group of employers. However, it did not apply to workers who were owners, co-owners, founders, board members, directors, and so on of the company, that means of an employer. It was determined that the threshold for participation in the share capital of the company in the amount of 25% is a threshold for the use of the measure, and so on and so on. To conclude, the measures were helped the economy under the jurisdiction of the Croatian Employment Service. There were two measures by which the service operatively implements the decisions of the government of the Republic of Croatia. The first measure is support of the preservation of job in crisis activities affected by coronavirus, which provides employers with financing for the salary in the amount of 530 euros for each workers. The addressee of these measures are not only companies whose businesses is disabled or impeded by measures of public authorities, but also craftsmen, family firms, sports association, etc. Employers who met the published condition and submit a request for support of the service, employment service, enter into specific agreement with that service, which legally has the significance of the contract of civil and not administrative law, with all the effects arising thereof. Complementary to first measure, the measure of reduction of working hours enables employers to reduce the working hours of workers so that they cover the part of the salary that falls on the reduced working hours, up to the 300 euros net per month per worker. These measures have significantly helped employers who have found themselves in financial difficulties due to pandemic, and thanks to them, many jobs in vulnerable economic activities have been saved. Thank you for your attention and for questions after.